So throughout the whole semester, I'm going to be introducing you to very specific areas of psychology and law. And probably through that process, you're going to get an overall sense of what psychology and law is. But to just kind of set the stage and give you a little bit of context upon which you can put all these things we're going to be learning into, I thought it makes sense to just give you a little bit of background. What is psychology and law? Some of the history of psychology and law. How is psychology and law? What does it look like on a day-to-day basis? So that's what the purpose of this recording is. When we're saying psychology and law, we're talking about any time individual behavior intersects with law or the legal system. It's a really broad topic area. I do specify when I first started out in my undergraduate work, I was a criminology major and a sociology major. Those are very different from psychology and law in that it's looking at larger systems like the correctional system, how societal things impact group behavior. And in psychology and law, we're really looking at the individual. And the way we do that actually can change quite a bit depending on what area of psychology and law you're in. So this is very loosely categorized, and I've categorized things into either clinical roles and non-clinical roles. By the way, there is some overlap, some back and forth, but we're just going to use these as kind of the basis of what we're talking about. So for clinical roles, there's really two primary areas: treatment and evaluation. So in treatment, you might have somebody who is a prison psychologist, somebody who's in a prison, working in a prison, and working with people who are in prison, whether they are depressed because they're in prison or whether they're in a special housing unit and we're doing a suicide risk assessment, all that sort of stuff. Police psychologist, somebody working with the police, doing evaluations of police, is kind of a slightly different thing you'll see right below, but still working with, if a police officer is involved in a shooting, kind of talking with them, doing treatment. Court-ordered treatment is something a lot of people do within psychology and law. So like anger management groups, if you're required to do anger management by a judge, or any sort of rehabilitation group that's ordered by the judge, that would or could fall into psychology and law. Evaluation roles, I break it into criminal and civil. So criminal, anytime anything like a crime has occurred or a charge has been filed, and there's an evaluation related to that. And so you think, like, are you competent to stand trial? You might not know exactly what that means at this point, but there's evaluations to determine, because you're afforded the right to a fair trial, there are evaluations that are conducted by people in psychology and law or forensic psychology to assess whether you are competent to stand trial, what your mental state was like at the time of the offense. You've heard of the insanity defense. That's something a forensic psychologist would do. That sort of thing. Dangerousness risk assessment, mitigation evaluations. There's a whole range of evaluations that are done within the criminal realm. And then in the civil realm, a lot of times you think of like competency to like execute a will. If you have like workers' compensation claims, somebody's injured on the job and they're saying, it's mental health injury. Let's say you have PTSD from a car accident when you were a bus driver and now you can't work. Trying to get compensation and pension. Evaluations of that type are civil evaluations within forensic psychology. And then there are a lot of non-clinical roles. So one, doing social science work. One of the things I was doing prior to doing more clinical psychology was doing research into the impact of technology in the courtroom. So doing research that involves psychological processes in the legal arena. Fact witness. You can be actually in any area of psychology and do some of these evaluations or roles, by the way. So let's say you're a developmental psychologist and you get asked by an attorney to come in and just talk about developmental psychology. Well, then you are now a fact witness working within psychology and law. Let's say you specialize in autism spectrum disorders and you've been asked to do an evaluation and for custody purposes. That would technically be considered a forensic evaluation and be within psychology and law. Something that kind of the last two items here, the trial consultant and policy analyst, those are things that kind of, they go outside the traditional psychologist role. But a lot of times people with training in psychology and law, you also then would have a lot of experience looking at the research, going through the different educational opportunities that could really prepare you for a role in one of those areas. Again, bringing individual behavior, intersecting with the legal system or with law, shifting laws, changing laws, offering your opinions on how law should be interpreted based on what you know. Those are all things that would fall within psychology and law. And again, this is not an exhaustive list, but it kind of gives us a place to start. Psychology and law, if I could break it down, is widely and all-encompassing. It can cover every other area of psychology at some point, just depending on how you end up using your training. So it's something that even if you don't go specifically in to be a forensic psychologist, you certainly could use what you learn here. So let's just give you a little bit of history of the field of psychology and law. I start on this slide with Hugo Munsterberg, 1908, on the witness stand. If you click that little link there, it'll bring you to an electronic copy of it. It's actually fairly easy read. It's pretty short, and it's really interesting because it's just a little scary where they started. But even before Hugo Munsterberg in 1908, things were already starting up for psychology and law, starting with Sir Francis Galton, 1883, started talking about criminality as it relates to, we had just had his cousin, Darwin, had come out with The Origin of the Species, and so he was kind of trying to understand how change over time could impact and relate to criminality. And then just shortly after that, Cesare Lombroso published a couple of books on criminality, talking about how people might have evolved more towards criminology, and he actually later his field became known as criminal anthropology. Late 1800s, there is a guy, Albert von Schrenck-Notzing, who testified about pretrial publicity, preventing witnesses from distinguishing between what they actually saw and what had been reported. So we start getting people working in the field before Hugo Munsterberg steps up and says, yeah, this should be kind of a field. We need to really explore this more. But then he is the one who kind of first stepped up and did that. His focus area was mostly memory distortions. It actually built on some of the work of William Stern, who looked at memory of students about 45 seconds, I think, to a minute after an exposure to a stimulus. But he was looking, Hugo Munsterberg was looking at eyewitness memory distortions, and he was the first to really call for research into the legal system. And then after that, we have William Marston, 1917. He was a Harvard psychologist, and I have these pictures up here because he is known by many comic book aficionados as being the creator of Wonder Woman. So he's actually, his mark of fame there is he discovered a connection between lying and an increase in blood pressure. If any of you have seen the Wonder Woman series or the comics or anything else, you will know that she has the lasso of truth and goes around you, and you cannot tell a lie with the lasso of truth around you. And so it's directly from psychology right there. He's also really well known because he testified in a case called Fry v. U.S. And this case is known within psychology and law about this idea of standards of admissibility. So what can you do to have evidence, expert evidence, admissible in court? And the premise was that, and the quote is, it must be sufficiently established to have general acceptance in the particular field in which it belongs. So in this case, the defendant Fry was tested with the precursor to the polygraph, the lasso of truth, and showed him to be telling the truth. Unfortunately, based on this, actually, this Fry standard, Marston's testimony wasn't allowed because the polygraph had not been generally accepted. So a little interesting footnote. Following, the field just continued to grow. Harvard created a chair of legal medicine in 1932, just kind of showing the trend towards specializing in forensics. In 1954, Brown versus Board of Education, social science was cited in a majority opinion, really looking at developmental psychology. The 1969 American Psychology Law Society was formed in the 70s. Elizabeth Loftus, if you know anything about kind of eyewitness memory, she's one of the big names, and she started doing a lot of her work in the 70s. 1974, the first psychology and law graduate program was founded, University of Nebraska, by Bruce Sales. He was at Arizona. I think he's now retired. As a side note, an Alabama plug, Alabama had a correctional psychology program as early as 1971, but it wasn't really a psychology and law program until later. 1977, Law and Human Behavior was founded, a premier journal within the field. 1981, Division 41 of APA, the Psychology Law Division, was created, and in 1984 it actually merged with the American Psychology Law Society, which was formed back in '69. It merged in 1984. So since then, the field has grown exponentially, and now it's really just, it's kind of gone into all different realms, including like neuropsychology, all different areas, developmental psychology. There's more and more research every day coming from different areas and how it relates to legal processes, simply because the law and interaction with the law is pretty prevalent across our system. All right, so let's talk about our influence on the law. How has psychology influenced the law? And how do we influence the law? So there's actually a few ways that we do this. One is through amicus briefs. The American Psychological Association and the American Psychology Law Society, they take a whole bunch of information from different research and they form opinions that is, in theory, it's psychologically sound, and it's consistent with best practices. And they submit these amicus briefs for review, and then judges, including Supreme Court judges hearing cases and other judges, can look at that information and try to make a determination for whether that's relevant to the present case. There's actually instances where it has directly affected legal outcome, and one example of that, for example, is as it relates to intellectual disability. The standard across many states was to follow the criteria as defined by the state for what it meant to be intellectually disabled. And so in a lot of states, that meant the person had an IQ of 70 or below, and of course the adaptive functioning deficits. And so within the field, we know that somebody with a 71 or 72, because of the standard error of measurement, could technically have intellectual disability. Psychology allows us and affords us the opportunity to diagnose somebody with an intellectual disability, even if their score on an IQ test is a 71. Well, that's not how the law interpreted it, and that's how state laws were interpreted. And so there were a lot of people who would have a 71 or a 72, could be found to be intellectually disabled by the evaluating psychologist. That report would be written saying they had an intellectual disability, but they would not qualify for the pass on execution, which, in other words, in a lot of states, if you have an intellectual disability, you can't be sentenced to death. But these people would still be sentenced to death because they didn't have an IQ of 70. And so psychologists wrote an amicus brief, and in fact, later on, it's now since been accepted that it's not a hard, fast rule of 70, and North Carolina was one of the states that had that rule that had to be 70 or below, and since that Supreme Court decision that was partly based on that amicus brief allowed the ruling to kind of go system-wide, and now North Carolina, if you have a 71 or a 72 or whatever, if a psychologist thinks you have an intellectual disability and can argue the case, then that is sufficient. Another way is expert testimony. I actually do a lot of this. Let's say, there's a question of an eyewitness, and there's some question about whether that eyewitness is a valid or reliable eyewitness. I've actually gone to hearings, they call them suppression hearings, to have an eyewitness statement suppressed from the record so that you don't have it presented to the jurors. And so certainly it can, a psychologist could go in, give information based on the facts of the case, and then that information can serve to influence overall outcome on law. And then finally, legislation, kind of related to the eyewitness identification thing. Throughout a lot of the research, psychologists have consistently been talking with legislators and amicus briefs and otherwise about some of the problems with eyewitness identification, to the point that, like, North Carolina has an Eyewitness Identification Reform Act, legislation that was passed to set up some standards for how eyewitness identifications were to be conducted. So these are just some of the ways. Judges are very mixed on how willing they are to accept psychological research directly into the courthouse. Some judges don't think they need help interpreting the law or understanding what should or should not be allowed. But for the most part, this is kind of a long process, and we keep pushing. And these are some different ways which psychology have been able to influence the law. So why is it so hard mixing psychology and law? And the biggest thing you run into is this one area, psychology, empiricism. We're trying to scientifically look at information versus justice. So these two things, they shouldn't be competing, but in essence they are. And I'll explain why. And this is kind of I think a good metric or a good illustration, just that kind of give the comparisons between the two. The purpose of psychology is to be descriptive. We're trying to explain human behavior and explain what's going on in people's heads. Law, it's not designed to explain human behavior. It's designed to guide human behavior. If you kill somebody, this is your consequence. If you drive over the speed limit, this is your consequence. So, and there's not really this care so much about why somebody killed somebody or why somebody drove over the speed limit. Sometimes that could be mitigating information, and sometimes it does have to do with the act. So, for example, killing somebody in an act of self-defense certainly can be, but that's actually a different behavior. So those are just significant differences in how you conceptualize the purpose of psychology versus law. And then you have kind of underneath that truth. The goal of psychology is to just seek out truth. Science, it's all science, is to find truth, find fact. You come up with a theory or a hypothesis or a treatment or whatever, and you're trying to always get better. You're always trying to refine that theory to be more accurate, more like truth. You're willing to challenge yourself, question yourself to be more truthful. Law, it's not really about truth. One would hope it is, but more than that, it's about justice. We have to resolve a conflict. You murdered somebody, there's a consequence for that. We need to decide with this. We have this adversarial system. It's not perfect. It's not like a system of everybody working together to try to find out the most likely thing that has happened. Instead, it's one side trying to say you did it, the other side trying to say I didn't, and we try to resolve that conflict. There's certainly some pros to that approach. There are also some negatives, but because of that, psychology and law don't always jive as well as one would like. Psychology is always future-oriented. We're trying to seek out truth. We're trying to look for examples of things and shift future behavior, whereas the law, it's past-oriented. We're looking at case law. We have legislation that came out. Judges are trying to interpret those laws, and then you look at case precedents, things in the past, to see how to define how to characterize what's going on now. I kind of referenced this a minute ago, the objective versus adversarial. objective in theory. We look at everything with an open mind. Is this possible? Is this something that we truly think could have happened? What supports that? What goes against that? Let's kind of look at all this. And in law, it's adversarial. It's one-sided view of facts. We're trying to look at the facts from one side and push one side, and then the other side, they're trying to force their facts. But a lot of times there's, going to extremes, there's gross generalizations, and the purpose is simply because, you're trying to win a case. Whether you're the prosecution or the defense, you're trying to make your case and have the judge or jury decide in your favor. And so certainly it's not the open-ended, let's have this objective discussion about everything. And in fact, sometimes information is forced to be left out of a trial because they think it might be too prejudicial. The case in point earlier of the eyewitness identification. And then psychology is all about probabilities, shades of gray. We're about here. Maybe there's a little bit of truth in this. Maybe it's not. Let's kind of explore a little bit. Whereas law is all about certainty. It's yes or no, guilty, not guilty. And they certainly have different requirements for that. So you can be guilty beyond a reasonable doubt. And then there's other legal standards. So like a preponderance of the evidence and other things. But essentially, it's this black or white. You are or you're not. And so those things just don't jive as well between psychology and the legal world. So the last thing I'm going to talk about is this idea of this ultimate opinion. We're going to talk about the ultimate opinion more throughout the semester, but this is something that comes up a lot for psychologists who actually end up working a lot in the courts. And that is this idea of, is this black and white thinking versus gray. I might be more likely in an evaluation for competency. If somebody evaluates me, a psychologist were to evaluate me to see if I'm competent to stand trial, that evaluator will try to give as much information as they can to outline for me what pros there are to suggest that I am competent and what things there are that say I'm not competent, and kind of give that happy picture. Whereas the law is going to say, no, is he competent? Yes or no? Do you think he's competent? Well, competency is not a psychological question. Competency is a legal question. Same thing with insanity. You often hear the psychologist or psychiatrist came in and they said he was insane at the time of the crime. No, the psychologist did not come in, or is not supposed to come in and say that that person was insane. Insane is a legal statute. That you cannot look in the DSM and find anywhere where it says somebody has the insanity diagnosis. And so both competency and insanity are legal issues. And because those are legal questions, psychologists really shouldn't be answering them. However, I've been in many a situation where I'm sitting there on the stand and the judge looks at me and says, "Doctor, is the guy competent or is he not? Was he insane at the time or is he not?" And trying to force that, what they call the ultimate opinion. So you're going to see a lot of things in some of the readings when we get to that part of the semester, but really whenever you're asked a legal question, is this person competent to waive his Miranda rights? Is this person competent to execute a will? Is this person or was this person's PTSD formed in the military? Any of those things, those are all legal questions. And so you have to do your best to give the information available, but just be wary of the ultimate opinion. That's one of the sticky points between psychology and law. And so that's just kind of a quick primer, and hopefully that gives you a little basis for what we're going to be talking about this semester, and give you just, I guess, some context through which to see everything else. I'd be happy to talk about it more. I actually have a whole presentation that talks about the history of psychology and law, different areas of psychology and law, and so certainly I'd be happy to talk more about those with you as the weeks come.